Hey everyone, Dan McKenzie here with McKenzie Law Firm. We are an estate planning, estate administration, and small business counsel law firm in the Denver, Colorado area. And wanted to make a video today about something that a lot of our clients ask us about. It's called the independent trustee. And a lot of our documents will say the outline decisions that a trustee needs to make, and every once in a while I'll say, well, my independent trustee needs to make this decision. And like I say, a lot of clients ask us, well, what does that mean? What is an independent trustee? Why is that different than a normal trustee? And so what's important to understand about this is that when you are talking about trusts, a lot of people are setting up trusts not just to avoid probate, but also to get some asset protection and maybe avoid some tax payments. And so both can be achieved, but usually in order to achieve one of those or both of those things, there needs to be some loss of control, some giving up, some element of saying, look, I'm not just putting this money into this thing and then continuing to control it as I always have. I really am giving up something, because before the IRS or before the US court system or before any collection effort is going to respect the fact that this money is outside your control, it really does need to be outside your control. And so a lot of people come to us and they want to set up revocable living trusts, and will tell us that one of the reasons they want to do it is to get asset protection for themselves. And honestly, a revocable living trust doesn't do that. And the reason is because usually when people set up revocable living trusts, they're the trustee of those trusts. And it's revocable, meaning that they can amend it, they can change it, of course they can revoke it. They maintain full control over the assets. And so a revocable living trust has a number of benefits, but asset protection for the person who set it up is not one of them. And I'm always having to point out to people, like, you do not want to live in a society where people could just avoid their bills or avoid their debts by setting up a trust that they remain in control of. Because that would obviously be a problem if you were the one who got hit by the car. You were the one pursuing the lawsuit. You were the one who was owed money by somebody. You don't want somebody telling you to take a hike because they put stuff in the trust, because that would just be too easy. So, but there are ways to get asset protection, and one of those ways, of course, is to put stuff outside of the person's control who is benefiting from that trust. So whether that's a trust you're setting up for yourself potentially, or for kids, usually this is where this comes in. So let's say I set up a situation where I'm leaving assets to my kids in trust after I passed away. And my kids are minors, so they're going to have a guardian too. So the guardian is the person who provides their day-to-day care. And then they've got a trustee, and the trustee is the person who makes the money decisions for the kids. What are we spending the money on? Are we sending them to private school? Are we sending them to camp? Are we signing them up for this activity at school? Like all those kinds of things. So sometimes those people are the same person, right? So your trustee and your guardian might be the same. And what we want to make clear to anybody who asks is, for the protection of the people involved, that certain decisions do need to be made by someone independent. So what does that mean? Well, the IRS has a definition of independent. And what they say is, look, it's not a spouse, of course. It's not a parent. It's not a child. It's not a sibling. It's not a subordinate employee. So setting up instruments where I basically give control to one of those people really is not giving up control. What we want to avoid is a situation where people give up control on paper. So let's say they set up an irrevocable trust and they're trying to get asset protection again, so or do some sort of tax avoidance. Okay, but in reality, what they've done is they've put their 80-year-old mother in charge. They've made her the trustee. Well, anybody looking at that situation, like, yes, on paper, your mother's your trustee. You have to go to her now to get money out of this, and she could say no. The way you've drafted that trust all makes sense. But everyone knows that for all practical purposes, you are going to, your mother's going to do whatever you tell her to do. And so you really have not given up control again. It's really an illusory step that you've taken. So again, in most trusts, there are situations where it is possible. Again, a guardian is a good example, where I've got my guardian, they're taking care of my kids. Well, the guardian is going to need to make spending decisions that might benefit them, right? They might need to get a new car because suddenly they've got more kids than they had before. They might need to remodel their basement to build a bedroom down there for kids that they didn't have before my kids showed up. And so, but those decisions, like now they got a new car. Now they got a finished basement, like things that have benefited them specifically. And so again, you want to make it clear, not only to protect your kids, but also to protect the trustee, actually, that there was no self-dealing here, that this decision was made by someone who really truly was not someone who was benefiting from the decision. And so that's where an independent trustee steps in, is to make sure that situations where a trustee might personally benefit from a decision that they would make is not involved in the decision, doesn't have someone involved who would, again, be under their control. So we use that terminology frequently. And again, a lot of clients aren't real clear on what that means. So that's what that means. So if you see independent trustee language in your trust and are wondering why that's there, that's what that accomplishes. So hopefully this was helpful. Again, I'm Dan McKenzie with the McKenzie Law Firm in Denver. And our phone number, if you have any questions about this or any other aspect of estate planning, is 303-578-2745. And thank you for watching, and hopefully this was helpful.